Welcome to the next episode of NALA Talks, a micro-learning series presented by the Diversity, Equity, and Inclusion, or DEI Committee of NALA. My name is Terry Walters, and I am the chair of the DEI Committee. The DEI Committee works to address diversity, equity, and inclusion to foster meaningful, open, and constructive dialogues throughout NALA and to celebrate diversity of its members and leaders. Today's conversation will focus on technology and eDiscovery with our esteemed panelists. I'd like to introduce our DEI members. Joining me today are NALA DEI Committee members Candace L. Russell, ACP, Angela Oberly, ACP, Micaiah L. Clark, CP, and our esteemed CEO, Vanessa Finley. All of our committee members are NALA certified paralegals. We encourage paralegals to obtain their CP designation through NALA. For more information on certification, please visit our website at www.nala.org. I'm going to turn it over to Candace Russell to introduce our next panelist, Michael Q, President of ACEDS.
Hi, everyone.
Hi, Mike. Mike Quartararo is the president of the Association of Certified eDiscovery Specialists, the world's leading organization for training and certification in eDiscovery and professional development for the legal community. With over 25 years of experience in the legal industry, he trains lawyers, paralegals, and legal support professionals in information governance, eDiscovery, and project management and legal technology. Prior to ACEDS, Mike spent 20 years in leadership roles at Skadden, Arps, Slate, Meyer, and Flom, and Struck and Lavin, managing people and processes in eDiscovery projects and complex litigation matters. He then launched a successful consulting practice advising law firm and corporate legal leaders in the use of technology in the practice of law. He is a recognized authority and thought leader in legal technology, project management, and information governance. He holds the project management professional and certified eDiscovery specialist credentials and is the author of the 2016 book, Project Management and Electronic Discovery, now in its second edition. As the president of ACEDS, Mike is responsible for the strategic direction and growth of the association, which serves 2,600 members in 30 chapters worldwide. He also contributes to product development for Barbary Professional Education. He is passionate about educating new and young lawyers, paralegals, and legal professionals and advancing the standards and best practices in eDiscovery and information governance. ACEDS provides live and online educational programs and resources to corporate legal departments, law firms, the government, and the broader legal community. Mike is a sought-after speaker, a renowned consultant in the legal community, and an author on topics including project management, electronic discovery, information governance, and innovation to legal technology. Welcome to NALA, Mike.
Thank you, Candace. Thank you for having me.
And now back to Terry.
It is my honor to introduce Sheila Grela, ACP ACEDS, as a senior paralegal at Buchalter. She is an active leader in the legal community through the San Diego Paralegal Association and Women in eDiscovery, and she frequently writes and speaks on technology, professional development, and durable skills for legal professionals. Sheila is passionate about mentorship, advancing paralegal education, and helping legal teams build stronger cases through the smart use of technology. Sheila is a seasoned litigation paralegal with an advanced certified paralegal designation in eDiscovery. She earned her paralegal certificate with honors from the ABA-approved USD Paralegal Program and was honored with the prestigious 2022 Gay O'Connor Go Spirit Award. With extensive expertise in eDiscovery, Sheila has achieved certifications as a Relativity Review Management Specialist, RRMS, and a Certified eDiscovery Specialist, CEDS. Her dedication to advancing the legal profession has been recognized through her appointment to EDRM's Global Advisory Council and her active role in the EDRM term project, Testimony Evidence for Record Management. This initiative focuses on improving the handling, accuracy, accessibility, and security of legal transcripts while integrating emerging technologies, ethical standards, and privacy protocols. A passionate advocate for professional growth, Sheila champions training, education, mentorship, and development within the legal community. She leads the initiative Virtual Lunch with Leaders series, a collaborative weekly program with SDPA, EDRM, and Practice Aligned Resources designed to foster meaningful conversations with trailblazing industry leaders. Sheila also serves as director of the San Diego chapter of Women in eDiscovery, demonstrating her commitment to empowering legal professionals through collaboration and education. Welcome, Sheila. I'm going to turn it over to Angela Oberle to introduce Michael Harris. Angela?
Over 15 years of experience as a litigation attorney, Michael Harris stands at the intersection of law, business, technology, and innovation in the field of eDiscovery. His career has been defined by a commitment to leveraging cutting-edge legal technology to enhance case outcomes. In addition to his legal expertise, he has owned and operated coffee shops, gaining valuable insights into budgeting, operations, and customer service. This diverse background allowed him to understand the unique challenges businesses face and to address them with a strategic and efficient approach. He is dedicated to resolving issues effectively, ensuring that legal processes align seamlessly with business objectives. Welcome to NALA.
Hey, everybody.
And now I turn to Micaiah Clark to introduce our next person.
Perfect. Thank you so much, Angela. It is my great pleasure today to introduce June Hunter, ACEDS. June Hunter is a technical enablement lead for legal software company Disco, where she trains firms and teams on legal technology. Prior to joining Disco, June worked as a paralegal, IT services provider, eDiscovery specialist at CGS3 LLP, a boutique real estate firm in San Diego. She is equipped with powerful combination of IT systems expertise and legal experience, and has a unique capability for recognizing and resolving the complex issues encountered in a law firm environment. A graduate of the ABA-approved Paralegal Studies program at UC San Diego, June has worked in the legal field for 36 years in roles such as legal secretary, paralegal, litigation support, and computer software trainer. Her industry experience and talent has made her the go-to provider of clear, hands-on training for other legal professionals in how to efficiently use legal software. So thank you so much, June, for joining us today, and welcome to NALA.
Thank you so much. It's a pleasure to be here.
Thank you. And to kick off this conversation, I'd like to begin with the first question here. Can you briefly explain for our audience what eDiscovery is and outline how the overall process works for us?
I would love to. It's a topic I'm often asked about. I think that the understanding of eDiscovery is something that lots of legal professionals have oh my gosh, this is such a difficult topic, but it really isn't. It's really discovery, right? It's where those parties that are involved in litigation or even internal investigations preserve and collect, then they review and exchange that information in electronic formats, right? And it's for the purpose of using it as evidence. Through that process, parties are going to identify relevant or responsive, non-privileged electronic documents. And so that gets us to the ESI part of it. Understanding that it's electronically stored information and gathering that evidence from those different areas. Could be cell phones or computer systems or even messages like chat or Slack or WhatsApp, those types of things. And I think that's what scares people the most, but it's a simple process. You're just gathering data that needs to be reviewed and then electronically produced. Does that make sense?
That does make sense. Thank you so much for that breakdown. I'm going to turn it over to the next DEI committee member for the next question, please.
What changes in the law have impacted eDiscovery practices? Sheila, would you be able to assist us with this question?
Yes. In December of 2025, the federal rules were changed, and they focused on privilege logs. The privilege logs have always been a problem for everyone. Do you have to do one? Can you complain about it? What's in it? So many different things. But the focus now is on adding it to the actual Rule 26 conference, and everyone needs to explain what they want done with the privilege log and how they're going to handle it. I know it is a tedious task, but knowing in advance what you're required to do or what you can require the other side to do is always important. And ESI protocols are an essential tool for everyone who's in federal court.
Thank you, Sheila. I'm going to turn it over to, I believe, Candace. Candace?
Has there been any significant procedural or regulatory shifts, such as the increased use of remote appearances versus in-person appearances for court?
Many of the courts have made public access to Zoom or virtual hearing opportunities to the public. And this is including Los Angeles Superior Court, I believe, has many stations within the courthouse where you can look and see where a particular hearing is at by watching it. And I think that this change has made things easier for the public as well as for the attorneys. Now, the attorneys participate virtually or via Zoom, depending upon what we're looking at, by a separate system. But the fact that they're now letting the public watch but not participate in many of these events, I believe is going to have an impact on how everybody sees justice being applied. The other issue is that everyone is concerned with how much time they're spending on the road, how much time their clients are having to pay for them to travel, or the expenses depending upon the circumstances. So an attorney in Northern California who has a license in Texas can appear in Texas via remote hearings. What that does is allow them to stretch their practice to a larger audience, but it also allows the clients to not be paying for things that don't necessarily add value to what they want done in the litigation or other matter that's going on.
And I think you just answered the next question. From your perspective, does the accessibility and convenience of virtual appearances enhance the client experience? Because they're saving money and they could be wherever for their court appearance.
Right, but the one thing that isn't being discussed is the judicial economy of it, which is an important part in our justice system. The judges only have a limited amount of time. So anything we can do to make it easier for them to get through the roll call, to address everything fast. So as an example, I was very impressed to find out that one of the courts required the attorneys before they entered into the virtual room to provide all of their information for the court reporter, including the case caption information. What this does is allows the court not to have to wait for that amount of time that normally would be covered by the attorney having to read off his or her information. And I know it seems like it's not a lot, but when you have 50 events on a given calendar on a Friday, that's a lot of time you've been able to take off the calendar and also make the life of the court reporter and court clerks easier, because this is an automated system that allows the court to make sure they're keeping track of who is appearing for each matter.
Exactly. More efficiency is always good. Okay, and now I'll turn it over to Angela for the next question.
I think this question might be for the mics. What technology tools are most effective today for managing document review and production?
There are a bunch of tools out there that are available that do a range of things, whether it's TAR or CAL or some of the AI generative AI products that are out there. And what they're doing is it's helping you to organize the data more efficiently and more effectively. It's you can thread documents now. You can cull certain documents out so that you're not looking at the same thing over and over again. But there's also exciting technology that can do summarization with some of your documents, and you can run it across depositions. You can do a deposition summary, so you can get upfront information about what the deponent said. And there's technology that can run it across different deponents. So you can say, I can run 5 different depositions. I can run a summary to see where are the inconsistencies in what the deponent said. And that can also be run against a document set or a database. So you can now see a deponent said certain things that doesn't really correspond to what's said in the documents. Now, is it 100% accurate? No. But does it give you enough information so that you can go hunt it down? Yes. And that's where you're getting more efficiency, time-saving ability, and just a better understanding of what you have in your documents. So I think the advent and the ability to use the emerging technologies is going to help tremendously with getting a clearer picture of what your case looks like. And conversely, you can use the same thing to attack what the opposition has. So you're running the same type of software on opposing counsel's documents, opposing counsel's depositions, and finding the fatal flaws. So again, does it replace the good, the tried and true methods of reading and making sure everything is accurate? No, you still need to verify it. But these things and these technologies are going to allow you upfront to get a better understanding of what you're internally facing and also what you're facing from opposing counsel.
I heard the question. It immediately reminded me of the ways we used to do this in the old days. I've been in this business long enough to know that we used to do this all in paper and boxes, and I can't imagine. And I agree with Michael Harris. There's just no way that you could conduct discovery today without some of the technology platforms. And these eDiscovery platforms, they come in different shapes and sizes with different bells and whistles and all these different things, different price points, and some for small cases, some for big cases. I just can't imagine. I just wanted to put an emphasis on the idea that managing eDiscovery without an eDiscovery platform today, I just don't know how it's done.
Okay, June, do you have anything to add?
I'm going to add to Michael's talk about the olden days. I started doing eDiscovery in 1998. We had boxes, we had bait stampers prior to that. And so it came on the scene for me in 1998. We still have lots of firms that believe software programs like Adobe is an eDiscovery program. It is not. It is a way to place a label on something. And in my position at Disco training clients, I have these conversations daily, unfortunately. And as Michael Quartararo points out, we have a tremendous amount of data out there. And so webinars and talks like this one, I think, are exceedingly important to reach a larger population of individuals to explain to them why they need to use those specialized tools. And as Michael Quartararo also brings up, they come in different sizes and different shapes. And Michael Harris talked a little bit about the features of it. If anyone has been watching LinkedIn, you know that our company is going to be making available to our clients an agentic AI part of that. But already, when we think of document collections, just to give you all an idea, and when I say y'all, I mean the general public, we're not seeing a few hundred documents anymore. We're not seeing 15 boxes of documents. We're talking terabytes. We're talking millions of documents 1 million documents, 6 million documents, that come in that have to be looked at without using a tool specific for eDiscovery, there isn't an effective way to get through that data set. Also, when we talk about the ethics of eDiscovery, I like to focus on the billable part of that, because you shouldn't be billing your client to go page by page anymore. 70% of the cost of eDiscovery comes from human reviewers, and we know that the human eye misses things. So it is unfortunate that there are individuals that still view that as the olden days. I'm going to look at everything individually, but the reality of it is you cannot, and you're going to miss items. And counseling clients, from where I sit about that, is unfortunate that we have to have the talks, but we do. Data gets released that shouldn't be, or data gets overlooked, and that leads to things like motions to compel and unhappy parties, to that matter. So just a little thought of why it's so important to use the right tool for this, especially in today's age. And it's not meant to replace individuals. It's really meant to make you more efficient and to bring about a better workflow and understanding of that data set. So that's just kind of like my input. Sorry about that, but I'm really passionate about eDiscovery, if you all haven't noticed.
Thank you very much. And now over to Micaiah.
Thank you very much. And this question is for the entire panel, anyone who would be willing to answer. In what ways does technology help reduce the risk of evidence spoliation?
Evidence spoliation has been a problem for everyone. And what it really comes down to is having tools to make sure that data doesn't disappear, or that everything is kept and that you have full access and ability to track what was available at the time that the hold triggered. One of the reasons that this is working better than it did many years ago isn't just that people have tools. It's also because of the methodologies that people and corporations are using to save their data. Data hygiene has become more imperative for the average legal professional than it was 10 or 15 years ago. And it doesn't matter whether or not you are working in litigation or you're working in another discipline. I had the example that someone was talking to me about, and I thought it was a great example. We have corporate paralegals and corporate mergers or acquisitions going on, and they focus on data. They have rooms where they store the information and make sure that everything that is applicable to the due diligence of that acquisition or that merger is available. And that is one of the reasons that data applies to all areas of law, not just eDiscovery.
Absolutely. And then either Michael, anybody else have anything to add?
Sure, just to follow up on Sheila's discussion, the technology that exists allows for better data mapping, understanding where the data resides, who has the data, who should we look for. That cuts down on the spoliation, because you're making sure you're finding out who should be have a legal hold. And the legal holds now, just as June said, Adobe is not agent software, eDiscovery software. Excel is not a legal hold software. I mean, it can be used there, but there's much more efficient ones where you can do hold in place, and you can put it on an enterprise level saying this person's documents are on a legal hold. And then when you have some of these other software out there that allows you to collect it, that type of thing makes spoliation a little less prevalent, just because you can find the data, know it's and make sure that you are complying with your legal hold obligations.
Great, thank you so much. Anyone else would like to chime in here?
Yeah, so I'll just add too that technology can be a real double-edged sword. It's incredibly easy to alter an electronic document, even inadvertently, And so we have to be careful about that. But the good news is that, to I think Sheila's point earlier, is, these tools, and Michael's too, we could typically track down whatever happened. If someone hit delete, we could figure that out. If a device was connected to a machine, we can figure that out. There's ways to sort of gather an audit trail and understand exactly what happened. So I think spoliation is still happening, perhaps not at the scale that it may have before. But the good news is we could typically track these things down and figure out exactly what happened.
Wonderful. Well, thank you, panelists, and I will, June, please
I was
go ahead.
going to just add to that for a moment, because great items brought up by Sheila, Michael Harris, and Mike Q. I love the Excel is not a legal hold tool, and Michael Harris is absolutely correct. There are specific tools that are offered even by Microsoft to help hold the data in place. But one of the things that I encounter a lot is when attorneys or paralegals, I get on to train them, and like, yeah, my client forwarded me all those emails. I cringe at that. They shouldn't be forwarding emails. Or I just had my client take a screenshot of their, text messages, and they sent those over. Those are ways of spoliation as well. And so I think when we're educating legal professionals, we need to make sure that we are having those conversations about use the right tool, right from identification through collection and processing, and providing individuals with the information for that. Nowadays, you can easily go in and collect data from LinkedIn or Instagram or any of the social media websites very easily. They have step-by-step instructions to do that. It's actually very easy to collect email. And again, there are step-by-step processes for that. For your big corporate clients, they have those tools in place. But when we take a look at, smaller clients that have a smaller wallet out there, they think that cutting those corners is going to save money. And I'm the first person to say cutting corners never saves the client money. Having the discussion with them about the right way to do things, and those individuals knowing that leads to, as Sheila puts it, better data hygiene. So, Michael Q, who heads up ACEDS, ACEDS is a great place to go. The EDRM, which Sheila is a member of, is a great place to go. Those different organizations offer a lot of training and education. And so as part of the process, I encourage all legal professionals to come to NALA, to go to ACEDS, to go to the EDRM, get the knowledge you need. If you do not, one, spoliation is a really bad thing. There's a reason the word sounds a bit odd. It's because it's never a good thing when we're talking about that. But two, it leads to job security. Everyone who's afraid that, the sky is falling, it's not, but you need to tech yourself up. And that means get the education you need. Otherwise, you become irrelevant in this space. And being in that process of being irrelevant is not where any paralegal or attorney or lit support professional wants to be. So, and all of us that have been in the space for a long time, we freely give that support or mentorship that those that are new to eDiscovery or just new to the practice of law overall are willing to provide to anyone who asks us. So, ask away. We want people to do this the right way.
All great advice. Thank you so much. And then I will turn it over to Terry for the next question.
We have seen some eDiscovery platforms and providers collapse or exit the market. What factors typically contribute to these failures?
We've seen recently the disappearance of some tools, and some of those shifts, right, which have happened for a number of reasons. Consolidation, right? Firms like Reveal, they have acquired Logical, they acquired iPro, which iPro is really not in existence anymore. But it comes about because of that consolidation. Also AI integration, right? With the rise of generative AI over the past 2 years, there are platforms that just were not going to be able to integrate those LLMs for doc review, and so they became obsolete pretty quickly. Also, the shift, that SaaS shift, companies that couldn't move from an on-prem to the cloud fast enough lost their customer base as well. I mean, there's been a big shift to the cloud, and COVID helped bring that about so much faster than anything else. But those are some of the typical reasons we see that. But I am sure that Mike Q and even Michael Harris probably have a better understanding of that as well. So I am going to turn it over to the next individual.
Mike Q or Mike Harris, would you
I'm
like
going to
to?
dive in here and say there's a saying in our business, at least there used to be. I don't know. I don't hear it much anymore. Is you're only as good as your last project. And that applies to a vendor you've engaged, a software company you've used, whatever the case may be. And if something went terribly wrong, that's a factor that can, impact, whether that company continues to exist. The other thing I think is driving some of the change we're seeing is just market forces. And by that, I mean the sort of the business of it, right? Put aside the eDiscovery, the legal, all those things, just the business of it. Whether it's to acquire a customer list or to integrate some new technology. We've seen a lot of mergers. We've seen some companies just, evaporate effectively. That's not necessarily a reflection, I think, on those companies or the people who ran them. I think it's just market forces doing what market forces do. And that is just consolidation in the industry. We all seen, anybody who's been around for a while saw what it used to cost to process data and what it costs today, and you can do the math, so to speak.
Great point. Anyone else like to chime in?
Sure, I'll say something like, the graveyard for eDiscovery platforms, it's filled with companies that had, great functionality, but zero utility. As a managed review company, we kick the tires. We're technology agnostic, so we work with any platform that's out there. We try to find the right platform to fit the right, matter, whether it's a big matter, small matter. But what we will find would be platform technology companies that got into it for the tech side of it. They wanted to show how smart they were with the tech and what they can do. But that did not translate into how it's used from an eDiscovery standpoint, what the lawyers need, what the paralegals need, what do we need to do to be able to create our case? And a lot of it was, the user interface. Some of the things were great. It looked great. I mean, or the power behind it was great. But if no one uses it, it's useless. I literally had a company that I worked with that's a Fortune 20 company that spent a lot of money for a platform, but no one knew how to use it. So when it came time for them to use things, they always outsourced it and paid an additional, set of money to go to another review platform just because their internal people did not know how to use it. So I guess the real world utility is the difference between having, a tool and a toy. It's cool to say I have this and I can do all these things, but if people don't adopt it, if people don't understand it, or if it doesn't solve a problem, it's going to go away. So that's one of the things that we look at with some of the review platforms and why we see some of them going away.
Thank you, Michael. Sheila, would you like to chime in?
Honestly, they have covered it very well. And one of the reasons they've covered it very well is because they all are working in that particular area. And as a litigation paralegal, even though I see all of the things that are coming and going, I'm not participating in the basis for the problems or the basis for why the changes. But I will say this, the two Michaels and June have a unique perspective that should be listened to. They understand because they've been watching closely. That's my opinion, is to listen to them.
Thank you, Sheila. I'll pass the questions on now to Candace.
Okay, I think this next question is probably best answered by Sheila. Thinking back to what I call BC, before COVID, and in-person proceedings and the pandemic era shift to virtual formats, what does the new normal look like in 2026 now for courtroom and law firm technology?
The new normal ranges based on the type of firm and the type of law that they're practicing. obviously, there are many small or solo firms that are taking advantage of the fact that they no longer have to travel to court and that they can appear virtually. So that's kind of a given. But the other factor is that travel has been reduced for everyone, including large firms. I think one of the reasons that everyone has been able to flex and find a comfortable space is because there's not one method that is better than another by data. Everyone will say, I like working at home and this is why, but the data is not necessarily there to show where the production or productivity is for choosing one over another. I will say that the hybrid approach has become the norm. You have firms that have a minimum amount of days that you have to be in the office. You have firms that have methodologies related to you have to be in the office when there's a team event. It varies, but I don't think things will ever go back to where we don't have an opportunity to use remote as a tool. And that's what I'm happy about. I don't know that we're ever going to be able to say, okay, everyone's going to do this or everyone's going to do that. But I like the fact that we're going to take away that remote tool because now we don't have to have it. I think that's an important factor. And the other thing that's really important is the morale issue. There are a lot of people who do not want to be on a Los Angeles freeway on Friday afternoon. Okay. And the flexibility that has come from allowing your employees to work around these things is very important, whether it be having to go to a dental appointment in the middle of the week, so you work before and you work after, or whether it be that you just want to get a 2-hour jump on your trip out of town. All of these things are helpful because we no longer have the regimented attitude. It's 8 hours a day and you better be at your desk from 8 to 5. I really like that particular flexibility for the morale aspect.
And now I will turn it over to Angela.
How have multi-factor authentication requirements affected system accessibility? For example, in PACER or e-filing systems?
Happy to chime in. Multi-factor is a necessity these days, and any tool that doesn't have a way to authenticate is not a tool that I would recommend using or that I would use. But what it's done, though, is through like PACER, it's eliminated the sharing of credentials. I mean, we all know that the attorney has to go in and do the training, which I was the pseudo attorney at my last firm and said, yes, the boss did it. I went through that training. And we would just log in with that. But now it's killed the practice. However, what it has done is it allow up to, I think it's like 10 authentication apps to be linked to a single shared account. And what that's doing is it's accommodating staff. But it requires management, right? I think has created more oversight, but a lot more safety. And a lot of e-filing portals now have a strict timeout, a limit associated with them. So if multi-factor code isn't entered within, let's say, a 2-minute window, the entire filing session resets. But the downside of that is it could be a pain point for attorneys that are filing large volumes of exhibits or late night emergency motions. And it could also be problematic if, let's say, it relies on a physical smartphone where you're using a Google Authenticator or a Microsoft Authenticator. Someone loses their phone or they have a dead battery. Now they're going to be locked out until they can reach PACER. And then we talk about third-party tool breaks, right? Legacy e-filing tools and automated document scrapers broke during that multi-factor rollout, and that required a lot of firms to upgrade to modern interfaces that would support more of a tokenized environment. So I think the last part of this is the shift to pro se litigants. We talk a lot about big spend clients because they're the ones who make the technology advance forward, I think, the most. But pro se litigants, right, and indigent users, we think that everyone has a smartphone and internet access. That is glaringly untrue. And I think a lot of us came to a better understanding of how many individuals really lack access to technology during COVID. There are whole communities where the majority of them don't have internet access. Living in Southern California, that's hard for me to wrap my head around. But if you don't have access to that, how do you get in if you're forced to use multi-factor? It's nearly impossible. So, I mean, I think those are some of the different driving factors for when we look at multi-factor requirements in PACER or different e-filing systems that are out there. I'm sure Sheila has some insight to this as well.
My insight is that people are going to complain no matter what method that we're using to be secure. We all have to spend time dealing with multi-factor authentication, but it is for the best. We are not having any of the previous problems where people are actually showing up and saying, I didn't file that document. That can't happen anymore because there's no accidental someone getting your password, using your email address and jumping in and acting like they're you. And that is really the whole point of multi-factor authentication. No one should be able to sign as if they're the person who's responsible for it unless they are the person responsible for it. And I know in San Diego, the federal judges probably about 3 years ago had this happen where an attorney went in and said, hey, well, we didn't realize our assistants had filed this, blah, blah, blah. And they, kind of threw them under the bus, and the court was unresponsive to that idea. In their mind, it doesn't matter. If someone is filing under their credentials, according to that judge, they were responsible. So many of the firms involved in this particular problem or discussion changed it. Everyone got their own set of credentials for filing and for looking or getting documents. And I think PACER is an example, but I think we have a lot of different things that are causing issues. You can't jump on a database anymore unless you have your email available to you so you can put in a secondary code. There's a lot of authentication that is being implemented to prevent people from stealing or committing fraud with tools that they shouldn't have the ability to use.
So do you think multi-factor authentication is here to stay in its current form?
Yes, but I also think that there are going to be changes in the future. I know at one time the County of San Diego had thumbprint devices on their computers. Didn't work out too well for various reasons, but I expect eventually there will be some discussion about what can we use, facial recognition. The real ID is, hey, you got the driver's license. Well, you also can go on and get a certified confirmation of who you are, and the government will allow you to use that to go into your IRS account or to other government accounts. The government has already figured out they have to provide a way for people to be verified. And it's really interesting that they've taken the jump on that, considering that most of the time they're behind the times.
I was just going to add to that for a second. I think that multi-factor authentication will continue to evolve. a really smart IT person said to me once when we had a bit of a breach at one of the firms I worked at, and they were like, look, as we develop new tools to prevent data breaches, the bad guys get smarter. We're just training them in how to come in and, get into systems. So I don't think that there's any one specific way that keeps data safe. I think it's a layering of different tools and different software programs. I mean, we see that at Disco where I work. We have an amazing IT team, and I can tell you we have like 16 layers of encryption. I always feel like I'm unlocking one door after another, but we house a tremendous amount of data. So we have a great responsibility to keep that data safe. And during my tenure, I've seen lots of advancement in multi-factor, and I think it will keep evolving over time. It has to if we expect to keep data safe. I don't think it's any one tool either. I think, IT professionals and list support professionals have to be smart and savvy about it and understand that it's a layered approach. There isn't one tool that keeps your data safe. It is definitely multiple tools out there that are going to keep your data safe and keep people out of the system. And the weakest link is always the human factor. So making sure that your employees are trained and trained again and trained again so that they understand, one, the value of data and why you need to go about using multi-factor the correct way and don't share credentials and, be aware of those different phishing attempts and things like that. So I think it's going to change.
So turning to the ethical considerations here with the technology, what ethical obligations do attorneys have when utilizing AI-powered tools, particularly concerning accuracy, confidentiality, and client consent?
I think we have to look at how we're seeing the adoption and utilization of AI tools. And that leads to the ethical part of this. As I had indicated earlier, I think ethics and AI, when we talk about implementation, it goes to the ethics of it. And I have been on with some big AM law firms recently who have opined we're not using AI. And I work for an eDiscovery provider, and so they don't want to talk even about the AI tool because they're not releasing that in the wild, so to speak, at their firms. But they need to. Corporate America has said, and again, I've gotten on with clients from corporate America who are like, we have advised, our outside counsel that they need to be using AI tools. And if they're not, corporate America is shopping for those firms that are. So when we talk about eDiscovery, lots of firms that are embracing the AI part of it are using it to automatically review their data sets, right? So you have tools out there that you train those prompts and they will go into the data set. And I know at ours, it's like 22 to 25,000 documents an hour that eDiscovery tool reviews. So when we talk about those millions and millions of documents, imagine having to have like 30 reviewers and the cost of that, whereas you have a fixed fee potentially for having an eDiscovery software do it. And the recall and precision for ours is higher than human review at this point. So we can also offer what's called that defensibility of the tool, which the court looks for. And that ties into ethics and compliance with those ethics, right? We're seeing the adoption of AI tools to summarize depositions. Michael Harris talked about that early on in our call, and it's very accurate. Does it require human, review? Absolutely, right? You have to, one, know what the AI tool is going to do. Two, just because you have the tool doesn't mean you should use it, right? You need to figure out the right tool for the job. And we've talked about the different tools that are out there. And Michael Harris brought up a really key fact. Firms can adopt technology, but if no one knows how to use it, right, it's not going to get used. You're going to go back to the old way of doing things, or you're going to outsource to another services provider. When it comes to the ethical part of it, the ABA rules are clear. Judges have opined recently, and you need to know the technology. Don't just use the tool because you're like, it's really cool, and then something goes wrong, and it's like, well, it was the tool that did it. At the end of the day, that responsibility sits square on the shoulders of the attorneys who are involved in that matter. As a paralegal, I often am asked, what do I need to know? So paralegals are in a supporting role, but they need to have an even better understanding of ethical requirements and how those tools work so that we can support the teams that we're on, making sure that everybody has the training they need, they have the understanding of what happens, and they're meeting all those rules early on. So I leave it to Mike Q because Mike is, at the forefront, maybe more so than I am, of technology and the advancement of that and how that applies to the ethics of it as well.
And then Mike Q, would you have anything to add here?
Yeah, listen, putting aside just for the moment the ethics of it, the obligation to be competent, the duty of supervision and confidentiality. These tools are moving fast and furious, and it's very hard to keep up with them. And I think what our listeners really need to understand is the nuances in between these things. What is generative AI as opposed to machine learning? Mike Harris referenced, TAR and CAL before. It's important to understand those differences, how they work together, and where can you really get value out of using an AI-based tool. June referenced a couple of different use cases. Obviously, we've been using AI machine learning mostly in contract clause extraction and comparison for years. We're seeing it used in document review, in the case of categorizing documents. They're not, we say document review, but they're not actually, the AI is not reviewing documents. It's doing what it's told to do, comparing documents, summarizing documents. It's helping get through some of those mundane tasks that are time consuming. And that's really where the ultimate value comes from, I think. And we're going to see a lot more going forward with the advent of these agentic engines that I'm seeing now. We're going to see a lot of automation that is going to be you're going to be able to pre-program things to do things for you that normally you would have to sit back, think about, plan, and execute. So that's some of the value that I see that's coming from AI.
Fascinating. Well, thank you so much for your insight. Michael Harris or Sheila, do you have anything to add here?
Yeah, just to piggyback off what Michael Quartararo was saying, there is the duty of competency, knowing what the AI does and how to use it, how to supervise it. But there are other small things like, understanding, and ethics in the use of AI for things like billing. We've heard cases about people who are typically writing briefs and spending 8 or 9 hours to write a brief are now doing it using AI, writing that same brief in about 5 minutes, checking it, and then still billing the 9 hours. So those are the things that, billing, you have to deal with the ethics of it. You have to deal with the ethics of, unlicensed practice of law. If we're using generative AI, or if we're using AI to do a lot of the work and still pass it off with, it's a thin line, but these are the things that we try to think of holistically of, if we're having the technology to use and do a lot of the work, at what level do we need to make sure we have the correct oversight? We're checking on the hallucinations, making things right. And also the transparency and saying, this is what we did and this is how we got there. Questions resolve around, well, if I had to pay for a subscription to use an AI, use one of the AI, legal AI tools, can that be passed on to the client in their bill rate being a little bit higher? So there's a lot of, between billing and transparency, in addition to the confidentiality and the competency of things that you have to look at with regard to the use of AI in law.
Absolutely.
Thank you very much, Micaiah. Let's close with an often overlooked and absolutely essential part of the ecosystem, paralegals. How are paralegals currently leveraging eDiscovery tools and broader legal technologies to support case teams? Sheila?
Well, I want to thank Nala for giving me the opportunity on multiple occasions to point out that certain tools are not being used as they should be. The one that I get on my soapbox about a lot is transcript repositories, because when I hear that people are still doing page line summaries, I'm wondering if they're just not realizing that their firm already has equipment or software, whichever you want to call it, because it's a little more than just software, to allow them to code and organize the transcripts for future use and to continue to add to it as they obtain new information. One of the problems is that many times the paralegals are the only ones that are realizing the potential for these tools. So one of the things I always suggest is to make sure you know what tools are available for your team. Try and watch what's not being used, and then give guidelines and value to the people who aren't using them. So I always say, if you know you're going to have more than 5 transcripts in a litigation, let's get the repository set up. Let's match the repository to the coding in the database. Let's do this, because you have more of a chance of getting them on board when they are deciding what to do than after the fact. So I suggest that the first thing everyone do is look at the tools that are available. Even though we want to talk about what we can buy or what we can obtain, there's a whole lot of different tools that are being used repetitively. One of the ones that isn't AI that is saving so much time is ECFX. They have a filing tool that allows the electronic filings to go directly to the document management of the firm that is using it, and then it automatically sends it to the people who need it. So they're not having to change things continually. They just have to go in and change the setting. That attorney isn't on this team anymore. Okay, well, who's now on there? We have to start thinking about how we can save time by getting rid of administrative tasks. And sometimes it's not AI, sometimes it's automation, sometimes it's choosing to use a system that is already available to the firm and to your team. So there are plenty of examples that we could go over, but I mainly want to point out that eDiscovery is not the only thing we should be discussing. Legal technology encompasses so much more now. It goes the full gamut of the EDRM and before it, the IG component and, trial presentation. It's a vast expanse that is allowing people to come up with new tools or to learn to use the tools they have.
Very great response.
I hope you don't mind me thanking you guys, because
no, you're awesome.
All I was writing for a while was my soapbox speeches, right, June?
Yeah, I was going to actually come on and add to that. One of the things that you all may not know is I'm an adjunct professor in 3 different ABA approved paralegal programs. I teach legal technology at UC San Diego, as well as up at a school in the Bay Area. And I get legal professionals in my UCSD course that come in and they are barely able to use Microsoft Word. And wow. Sheila and I are at the, look, we're layering in advanced technology to things we do in our workflows, and we're coaching others to do that. And there's such a great big divide, between all legal professionals. We have the ones that are so tech forward and they want to learn how to write better prompts and what tools are going to make their workflow more efficient and how do they, bill more efficiently and effectively. And then on the other side, I have students that come in, they have been in the business for a number of years and they're like, I don't know how to generate a table of contents. I don't know how to generate a table of authorities. Those are some big issues that we have to address. And, there's this huge stigma that still surrounds the use of technology in many different areas of the law. I still have paralegals that say to me, I have to print all of these documents out so that the partner can see them. And I'm like, you could just generate the search in your eDiscovery database and send them a link. They click the link and it takes them and they're like, yeah, they won't do that. I'm like, but it's just a clicking of a link to do it. So there's this huge divide that I still see. And I'm on my soapbox a lot about get that education. It's not difficult. Learn how to use it. And if I could leave anyone with a parting thought about what training you need, if you're already tech forward and you're already using those tools, learn how to prompt, learn what those AI tools do that you're going to use. You need to have a really good understanding of that, and build that foundation now. Otherwise, you lose ground. Above the Law had an article say about Baker and McKenzie laying off 700 employees because they're using technology. And so when we say, that people are fearful they're going to lose their job, I think, and I could be 1,000% wrong because, what do I know? I just teach people that you'll become irrelevant. And I think I talked about this earlier. You will become irrelevant if you don't embrace the technology. And there are so many ways you can get that education. Again, I lean into ACEDS. They're an amazing organization that will walk you through a lot of the technology you need. You have the EDRM, you have your local Women in eDiscovery, your local paralegal associations, and then the different, ABA programs out there. Maybe you already have your ABA approved paralegal certificate, but did you get eDiscovery in there? Did you take a discovery principles course? These are courses that are offered at lots of the schools now that maybe they didn't have available when you went through. Go back and take them. Your firm will most likely be very supportive of you doing that. And if not, pay for it because it's important. You need to know these things, right? So that's, I don't know, maybe my parting thought about what you need to do going forward and why it's so important.
Well, that is key. Continuing education is key. And if you don't continue to learn, you're going to get left back. So Sheila, would you like to join in? And
I want to point something out that we always forget, and it's totally because we get ingrained in the actual thing we're talking about and forget. Management is a huge stakeholder in these discussions. Right. If you are interested in getting people on board, participate in IPMA, participate in NALA, participate in the people who are making the decisions so that they can support you. I know that it sounds like, oh, but they don't necessarily help. No, they have to know what's going on in order to direct the future. And many times we fail to tell them.
Well, not just tell them, but we have to explain it to them so that they can grasp it and stop cutting down the trees and start utilizing the technology that's around. Anyone else want to chime in on that? Michael?
Sure. Just want to chime in. I do agree with what June was saying with regard to jobs going away. And, it's not the sky is falling type thing, but you can see that the technology is going to it's not going to replace a job or take the job away. It's going to make the person able to do it better. And if a person can do it more efficiently and effectively, they can do more, which would replace those who can't do it. So I do say when paralegals are working in the eDiscovery space, the training is great, the certifications are great. I also say look at the human side of it and being able to be that conduit of what's bringing, as Sheila was saying, the conduit to making sure people understand what the technology is and how to use it and getting firm buy-in. The technology, it's a bunch of ones and zeros, but you'll never lose the human side of what you need to be able to make sure that you understand technology. And, one of the industries I would say just looking forward where I see a lot of growth is going to be in the compliance area. And paralegals working in eDiscovery and compliance, because there are things, the advent of data, so much data is out there now that data is the big thing. So now you have to deal with HIPAA compliance, you have to deal with GDPR and CCPA, the types of data privacy. And that requires companies are going to start they have requests, they have, when DSARs, when you get a request for what kind of data you have on it, you have to respond to that. When there's a data breach, if you can focus yourself on somebody who understands, the process for getting the data together and breach response. Even forensic side of it, that the understanding, the go-between with the IT and the law on the digital forensics, making sure that, the data is correct. Because you can create bad data now. You can do fakes. I can go to ChatGPT right now and create an invoice that says it came from somewhere and it's just false. So you have to be able to look at the forensic side of that. I think those are areas where paralegals can really kill it right now, because those are hot areas, those are necessary areas, and that's areas where you do have a lot of the lawyers who are the same way of wanting to print everything out and bring it in bankruptcy boxes. This is your opportunity to come in, show the use of the technology, the laws that needs to follow it, and how you can stay and be relevant and oversee those processes, whether it's from a compliance standpoint and or breach response, because data is out there and we need to be able to deal with it.
Thank you, Michael. Michael Q, you are responsible for training paraprofessionals across the nation. Would you like to chime in?
Absolutely. And I really just want to add, I mean, everybody did a fine job at hitting the high points. There's one thing I always like to point out, and that is, don't strive to be a generalist, strive to be a specialist. And what I mean by that is, my career spans 30 years. I started as a paralegal, but when I started introducing technology to the things that I was doing as a paralegal, it changed the game. And before I knew it, I was offered roles and leadership positions and management positions and so on and so forth. And the other point that I'll make is that, I think most paralegals have a general sense of what a paralegal salary looks like. I will tell you that eDiscovery salaries are in many instances twice as high as paralegal salaries. And that's something that's worth looking into. So learn the technology, get that certification, take that course, whatever the case may be. You're going to advance your career, you're going to earn more money, you're going to find your job much more fulfilling, frankly, because you're going to be involved in many more interesting projects. So that's my parting word for today.
I'd like to thank our panelists for sharing their insights, and thank you to everyone for attending. Technology continues to evolve rapidly, but conversations like this help our profession navigate these changes thoughtfully. We hope today's discussion has given you practical perspectives, some new ideas, and maybe a glimpse of what the next phase of technology will look like. Thank you again to Mike Q, Michael Harris, June Hunter, and Sheila Grela. Thank you so much for your time and expertise.